All right. It shows people coming in, so we'll give it just
We're
a minute.
on.
Okay. All right. I think we should begin.
Great.
Although it does seem like people are still coming in, but
We
give
could
it.
wait or whatever you think.
Okay. Well, I think it's slowing down now. Well, no, I shouldn't say that, but okay. Why don't we begin? Because we do have a lot to cover. So,
Mm-hmm.
welcome everyone. I'm Janet Aronson, and I'm with attorney Lexi Hulick, and we're excited to have you with us today. Lexi and I both deal with a lot of rules and violations. So this is an important topic to us, and we hope that it's an important topic to you because we think that being educated and understanding what rules cover and how to enforce them will make the process a lot better. Okay. So just a couple of housekeeping details. We are going to go through our presentation and then we will take questions at the end, and there is a question and answers button. So I think you can put your questions there and then we'll review them and we'll try to answer as many or all if possible. The other thing that I wanted to let you know is that this is being recorded, so there will be a link available after our presentation, so you can share it with someone else, or you can go back and watch it if you feel like you want to pick up on something else that you might have missed. So with that, I am going to start with what are rules. And to do that, I want to go back just a bit and kind of discuss with you why rules are important, okay? First of all, as you all know, condominiums and homeowner associations are a unique form of ownership. It's a joint form of ownership where owners own their units and collectively all of the owners own the common areas and amenities. So, with that unique form of ownership, you do have to have obviously rules and regulations that govern the use of those amenities because multiple people are using them. So we have to have rules and regulations. It goes hand in hand with the fact that you are in this joint form of ownership. Um, and it makes for, obviously, if people follow rules, which they always don't, it does make for a better community. So it's also important to understand that rules may be the only document that anyone reads. Most unit owners are not reading the condominium documents. They probably are really only reading rules and regulations, possibly. Okay. So we try to put the most important things into the rules and regulations and in a way that makes it easy for them to understand so that they are able to kind of follow these rules that we have set for the community. The bottom line is rules are important and they will hopefully improve the operation and administration of your association. But as we know, and Lexi and I both know this, people don't always follow the rules, and then we have to get into the enforcement. And what we find in our practice is that's when we go back and start looking at some of the rules, maybe the rules in question, and we get concerned. Well, it doesn't really say this. We can't understand it. So that's why we wanted to have this discussion with everyone today so that we can actually go over what are the best practices. Okay. So with that, I want to turn to what rules should cover. And they basically should cover three general things, okay? They should cover the use and governance of the common areas of the condominium or the HOA. Anything in the common areas, the board is typically vested with the authority to mandate what the rules are with respect to those common areas and facilities. So that is one general purpose of rules. You want to use a common parking area, there should be parking rules in the rules and regulations. The other important part of rules is probably to highlight certain restrictions that are in your governing documents. So those restrictions may already be set forth in the documents, but you want to reiterate them in the rules because, as we just mentioned, rules may be the only thing that someone reads. So we want to encourage those important parts of your documents to be included in the rules. And the other aspect of rules that's typically included is the administrative procedures for things that may be set forth in the rules. For instance, that for things that may be set forth in the condominium document. So, for instance, you may have a late fee policy that you want to make sure is in the rules because the condo docs require that owners pay common expenses, but your rules are going to say what the grace period is, what the late fees are. So those types of things are administrative in nature based on what's in your condominium documents. So those are the three important things that rules really cover. Now, that means what rules don't cover, and what they don't really cover is the use of the unit. So that is a distinction that's really important to understand because it's it's the fine line between what the board has the authority to put in the rules and regulations and what then requires an amendment to the condominium documents. So the distinction again is, and I'm going to repeat it, you should not be putting in the rules any rule that impacts the use of the unit. And the simple one is, if you don't have any pet restrictions except for what's in your rules, then you may not have enforceable rules. And Lexi, if you can advance the slide, because I do
Mhm.
want people to understand basically the hierarchy of the condominium documents and the rules. So you will see on this slide that the rules and regulations are the lowest tier of governance, okay? And they are subject to the declaration of trust, and then above that, the master deed or the declaration of covenants. They are then subject to state law and federal law. So when you are crafting rules, you need to recognize that rules are subject to everything that appears above this scheme. All of those other documents and state law and federal law supersede rules and regulations. So this is an important understanding of this whole process, because sometimes people will say, well, why can't we say no to an emotional support animal or a service animal? And the reason is because federal law and state law trump what's in your condominium documents and certainly trump what's in your rules and regulations. And what's in your condominium documents trumps your rules and regulations. Okay, so we have to be cognizant of the fact that rules are really the lowest form of governance in an association. Okay. So I think we can advance to the next slide. Okay. So what happens when you want to draft rules, new rules or revising old rules? And I think that process, it typically gets accomplished by a few of the board members or maybe a committee. Okay. It is difficult to have multiple people involved in the process. I mean, you can have a number of people involved in the process, and I think that's certainly fine, but I think that it becomes chaotic and cumbersome if you have like 10 people trying to draft rules and regulations. So I do encourage a few board members, maybe it's one board member or a committee, to be able to kind of start this process. And the things that you want to consider when you are drafting rules and regulations is start with your existing rules. I think start with those if you have existing rules. And most condominium documents and HOA documents had an initial set of rules that were put into place by the developer at the time the association was created. So I think you should always go back to that. Unless you have other iterations of it that came after that, then you would go back to your most recent set. And from there, you want to consider, well, what is really reasonable and necessary? I mean, is it necessary to have the rule? Is it not necessary to have the rule? I do think you should consider that. And the reason why I say it is because what I said at the beginning, people have limited capacity. They're not going to read 30 pages of rules. So we try to recommend simplifying it. And if you have rules that don't really apply anymore and not necessary, I would say get rid of them because you want them to concentrate on the important rules. And so it to me, having extra rules isn't necessarily a good thing. Okay. The content, you want to make sure that the rules are understandable, that somebody could pick up your set of rules, read one of the rules and understand exactly what it is they should or should not be doing. Okay. And it may be that you even have somebody outside of the community assist, like family member, friend, somebody to read the rule that you created and say, do you understand what this means? Because we need the average person to understand these rules. They can't comply with them if they don't understand them. So I think that that's important. It's also important to be clear and concise so that the rule is as easy to understand as possible. If the rule goes on and on, it does get difficult to read and understand. So I think having clear, concise rules and understandable rules does make a difference. I think the other aspect of drafting rules or revising rules is you're not going to capture every single instance of a potential problem. And I know board members get concerned about this. Well, we have to tell them every single thing they can or cannot do. And it's impossible. I can tell you that. So we need to have some rules that maybe expand a bit the board, what they cover, I guess. Because if they don't have any broadness to them, not too broad though, because from a case law perspective, more specific rules are better than broad rules. But we do need to have some rules that have some broad provisions, because if you don't, we're not going to capture every possible thing that can or cannot happen. And I'll give you an example. I mean, we have one association that had an owner who felt that they should be throwing their trash instead of going down to the dumpster. They felt that they should throw their trash off the balcony of the unit instead of actually going to the dumpster and dumping it. Now, who could predict somebody is going to do that? I mean, it's not really possible. In that case, if you had a rule that said, that no, that you have to use the common areas for their intended purpose, that might help. What we actually ended up doing in that specific case was we did ultimately recommend that the board adopt the rule to say you can't throw anything off your balcony. And so at least we had something specific, and then we put the owner on notice that this was being adopted. They continued to throw things off the balcony, but at least there was a specific regulation. And when Lexi gets into the discussion about, well, how do you enforce these things, it becomes important to have the foundation in the rules that we can actually rely on. So that's another thing that I'd like to say. And I guess one of the most important aspects of drafting rules is for the rules and regulations that you draft or revise to be compliant with what's in the condominium documents. Going back to the chart that we showed you, anything that appears above the rules and regulations, we need to be compliant with. So bottom line is we can't have a rule that conflicts with a provision in your documents. I'll give you an example of this. If you have condominium documents that say that a lease agreement only has to be in effect for at least 30 days, you cannot by rule change it to 6 months. It conflicts with what's in the documents, and the documents govern and supersede what's in the rules. So in that case, you really don't have the authority by rules and regulations to change the term of the lease to 6 months. You would have to actually amend the documents to create that restriction. Okay. So that is one of the most important things I think that you need to bear in mind when you are drafting or revising rules. So the way that I recommend that boards go about this process is, again, a few board members, a working committee that works on the changing and the drafting of the rules and regulations. From there, I think you would want to have legal counsel then review them. Okay. And we review rules for a couple of reasons. One, we go back and double check to make sure that they are compliant. And secondly, we can look at the language that you used in the rules and regulations, and we can make sure that they're said in the best way possible, in the cleanest way possible, in the clearest way possible, in the most concise way possible. So I think from a cost effective standpoint for boards to do this, you don't I don't think it makes sense to have the lawyer draft the rules out of the box. I think it's best for you as board members and as a committee to look at your common areas, look at what types of rules you need and put your best effort into drafting those rules. Then you would turn it over to council to make sure that there's compliance. And sometimes we're going to tell you it's not compliant. And you will say, well, what does that mean? And well, that means that if you keep that rule and you go forward with that rule, then you may not be able to enforce it. So we caution people. Yes, it could be a deterrent. It might be effective because most people don't understand the difference between rules and condominium documents. But at the end of the day, enforcement may be in question. So we don't really encourage boards to keep those rules, but you can't because you get to make the bottom line decisions. I think once you do that, another suggestion that I do have for most associations and something to consider is, do you want to share these rules before you formally adopt them with the unit owners to get unit owner input? And I encourage it for a couple of reasons. One, it involves unit owners in the process. It gives them an opportunity to comment. They might actually have some good ideas that you can rely on or that you can think about. Maybe you didn't consider it originally. And so I think that is actually helpful. And secondly, when one of the unit owners comes back, a year after they're adopted and says, well, I didn't know this was happening. And why did you create these rules? You can say, well, not only did we draft them, but we gave you a draft before we formally adopted them, and there were no comments, or you didn't comment. So I think that actually serves a couple of purposes. So I think that would be a helpful thing to do. And I think it puts the association in a better position when you go to enforce the rules. The only other thing that I want to briefly mention is about handbooks. And I know a lot of associations still do handbooks, and I actually encourage that. I mean, I think, yes, people go online and people will look at the website, and you can have all this information on your website, but it's often still handy, especially for the older people, of which I am one of. Alexi would disagree with how I do things, to have it in hand, to refer to it, because I'm going to maybe read it and I won't be inclined to read it online. So I think having a handbook is good. But the point that I wanted to make is that rules and regulations are part of the handbook. Okay. They are not the entire, the handbook is not the rules and regulations. The handbook typically includes things like information about the property manager. Where should you call if you have an emergency? How do I get an insurance certificate? Things like that. What days does trash come? So the handbook contains information about the operation of the association, but not rules. That's a separate thing. They can be part of the handbook because you want to give out one document and you want one comprehensive document, but rules are separate from the handbook. So I just wanted to make that point. Okay, I think with that, we are on to the next slide.
All right, great. So Janet talked a little bit about adoption of rules, and now I'm going to talk about formally adopting your rules. And in order to formally adopt your rules, you need to look at your condo docs. There's going to be a provision specifically regarding how you formally adopt your rules and regulations in either the master deed or the declaration of trust. So typically all that's required, at least for Massachusetts, is you need a majority vote by the board. Some states differ by this, like Rhode Island usually requires some type of unit owner consent. But for Massachusetts, typically all that's required is majority vote by the board. And usually it doesn't even say that you need to record your documents or to record your rules and regulations with the Registry of Deeds. However, our firm will always recommend that you record with the Registry of Deeds because this provides constructive notice for all future owners and current owners about the rules and regulations. And it's just a good idea to always file with the registry, whether it says so or not in your documents. So in addition to that, like Janet already spoke about a little bit, you do want to pass out these rules and regulations to make sure that all residents are informed of what the rules are, and educate them and just give them an opportunity to read through and have them available, whether that is paper or sending out an email with a set of the rules. It's always a good idea to make sure that all of the residents have the rules. So next I'm going to talk about enforcing the rules and violations. So what do you do now that you've formally adopted these rules? What happens when someone violates them? So the first thing you're going to want to do is verify the complaint or verify the violation. So in order to do that, you need to just make sure that the complaint that you have, verify it through independent corroboration. Sometimes these situations, if you receive a complaint, for example, it can be a he said, she said situation. So maybe if there's some kind of third party witness who can independently corroborate either side of the story, that is always ideal. It's also really important to make sure that complaints are usually in writing, at least. I know sometimes complaints can be orally, but you always want to make sure they are in writing because that will help you down the road. If, God forbid, you need to go through litigation for this violation because all of the processes that I'm going to talk about didn't work, it's just important that you have a paper trail of these things. And it always starts with having that written complaint. So, um, after you verified the complaint, oh, one other thing I did want to talk about is that me, Janet, and another attorney at our office were discussing yesterday was you want to make sure that whatever complaint you've received is actually a violation. So it's a violation of a written rule that you have, and that's just something really important. It's not something that may just be a one-off complaint. It's actually a legitimate violation. So after that, you verified your complaint, your violation, you want to put the unit owner on notice. And it's important to notify the unit owner and not a tenant, for example, because the unit owner is ultimately responsible for the unit and all of the occupants, tenants therein. So you want to put the unit owner on notice. And the processes I'm going to talk about, we always try and encourage our boards to try and go through these steps by themselves initially. We are always happy to help and answer any questions and obviously support them and do all the things we are going to do and discuss right now. But for the board to try and do this on their own at first before seeking counsel is ideal. So you're going to want to put the unit owner on notice that they have violated the rule. If you don't have our office send a notice of violation, you could maybe ask your property manager to send one out, just saying you have violated the rules. You have to give them an opportunity to cure the violation. And just making sure that's in writing again is very important. And sometimes also, I did want to say that if it warrants it, if it's a violation such as like harassment, you may also need to tell the complainer that they need to call the police. That may seem kind of roundabout or maybe obvious, but you do need to tell people if you feel unsafe, you need to notify the police if it's that kind of violation, again, like harassment, to ensure that there's a report of it, because those police reports will be used down the line if necessary to go to litigation.
And
And every
Lexi,
town,
some communities, yes, every town is different.
yes, every town is different. Yeah, every town is different. So sometimes you will call the police if you're in a condominium and they'll just say, this is a civil matter. You have to talk to your condo association. But there are other towns who will help, or town police officers who will help if there is a matter where you need to notify them. Either way, I think it's always a good idea just to at least try and reach out because there are police logs where it logs that you've called, at least even if there's not a written report. So, after you've notified the unit owner, another tool that you can use to enforce a violation is using the fines. Jan and I are going to talk a little bit about fine policies after this, but you're going to want to assess fines. And sometimes fining can only go so far, but it is important to use it if you think that the violation warrants it, and also be consistent with fining. And of course, make sure that the amount you are fining is reasonable. Um, Fining is not always, fines shouldn't always be seen as something that can be collected. The whole point of these tools are to make the violation stop, and fining is another method of notifying someone and that what you're doing is wrong. You've been assessed a fine that you now may be subject to pay. So it's important to um, assess assess fines, and sometimes you have to. Well, we'll talk about it a little bit after, but you have to look through your documents and see if there's a limitation on the amount of fines that you can assess and whatnot, but we'll get into that. Another thing that you can utilize when there's a violation is a due process hearing. So this is something that may be already in your condo docs, and that you have to provide the violator an opportunity to be heard in front of the board. If it is something that is written into your documents, you do have to follow that process. But it also sometimes is a rule that you can put into your rule and regulations. And it's just, again, making sure that the violator has their right to be heard in front of the board if they so wish, and discuss their violation and how they're going to stop it. And after all of those things, again, like I discussed, you can always reach out to us and help you. Usually, a lot of what I deal with here at MEEB is I do a lot of notice of violations and demands to cease and desist violations. So that is something we're well versed in. We handle a lot, and it's not always that one letter will work. I am occasionally sending out multiple notices regarding the same issue if they haven't complied the first time, and all of the legal fees that are assessed in matters such as when I'm writing a letter are accessible to the unit under the Massachusetts Condo Statute 6A2, I believe the section is. So that's another thing, is utilizing us and assessing the legal fees to the unit account. And then after all of these methods may have not worked, like you've sent them letters, we've sent them letters, fines have been assessed, they're racking up, they did not want to do process hearing. So then you may want to go forward with litigation, which Jana and I really won't get that much into. We're both general representation, and we have a separate department here at MEEB that completely handles litigation matters and are the masters at that. But I will just briefly discuss it, and that you usually utilizing these tools are very important, because if you do need to go to litigation, the first thing a judge will ask you is, have you sent out warning letters? Have you utilized the tools in your condo docs before running to court? And when you write a complaint for going through litigation, it will describe all of these steps you've taken prior to initiating this legal action. And when you do have to file a legal action in court, one thing I will say is that for the people who have been complaining about the violation, you will have to ask them if they would provide testimony or sign a written affidavit. And either way, when you file a legal action, there's a verified complaint that someone like the property manager or a board member or the person who's heard the complaints will have to verify and sign off on all of the claims that I've made into the complaint, which is public information. So your name is available for the defendant to see. And I know in some cases that can make people fearful, but I'm not telling you this to make you in fear of submitting complaints or anything, and knowing that your name may be exposed down the line. But defendants, people who are violating the rules and have a legal action against them, do have a right to face their accusers, much like in criminal law. So you will be asked to provide testimony or sign something with your name on it in the chance that litigation is necessary. So that's why it's also just important to make sure all of this stuff is written down. There's evidence that you've utilized the tools before you've gone to court. And I think that pretty much covers everything I wanted to discuss. Janet, did I miss anything on my part, or?
The only point that I wanted to make to everyone is, so the fines and the legal fees that you may incur in connection with the violation in Massachusetts, are assessed to the unit and they do constitute a lien on the unit. And we are going to talk about the fine policy, and I guess we can start with that right now.
Okay.
So we're gonna skip. I'm gonna skip around just a little bit, so bear with me. So what we're gonna maybe jump to rules every association should have, and I think one of the important rules that every association should have is a fine policy. And the reason for that is you want owners on notice that if they violate a rule or regulation or a restriction, this is what they're going to be subject to. And I know sometimes boards try to go through every single rule and say, well, this rule that will have this amount of the fine. And I understand that, but I don't think that that's necessary. I think you can have a general fine policy, and some associations have a warning letter first, or and then escalating fines as the violations continue. But the one important aspect of the fine policy is that the board has some authority to override that fine policy in an appropriate circumstance. You may have a simple violation, not putting the garbage cans back into the garage by a certain time. That may be warrant, the fine policy that you've set out. Or you may have a very serious violation, not one that you could predict, and therefore you want the ability as a board to be able to levy a larger fine. And as Lexi said, fines are supposed to be reasonable. That's what the law says, okay? And we do need to make sure that your condominium documents or your association documents don't contain a specific limit on the fines. I mean, for condominiums, we argue that the law allows for reasonable fines, and many older sets of condominium documents have like a $5 a day fine, which obviously is not reasonable today. So it would be my position that we would have the right to, increase that through a resolution or through fine regulations or rules and regulations. But it would also be nice to clean up those documents and remove that conflicting provision, just to give the board the right to establish the fine policy. And that obviously, once you do that, what is reasonable today in 5 years may no longer be reasonable. So that gives you some flexibility. So we always do recommend having a fine policy. I guess we can just keep going on what the other rules are that we recommend, because we want to have time for questions, and I know that there are questions. So a late fee policy. This is late fee on payment of common expenses. Sometimes your condominium documents or association documents will say when the common expenses are due. Sometimes they will give the grace period in the condominium documents or the association documents. Other times they're silent. So when they're silent, you can certainly adopt a rule that says what the grace period is. That's the type of rule that doesn't conflict with what's in your association documents, and it's administrative in nature. So that you could then say in the rule that common expenses not paid after the 15th of the month will be subject to a late fee of X. Okay, I think that's an important rule to have. Occasionally we do still go to court to collect common expenses, and late fees can be challenged. And many associations have them, but what's actually reasonable, I think, depends on the amount of your fee. I've seen associations try to make the amount of the monthly common expense fee be the amount of the late fee, and that obviously is definitely not reasonable. But I think it's an important rule that you do have and something that you look at. And then today, in these days, what I think Lexi and I have been finding is that there's a lot of what I would call offensive conduct, bad behavior that goes on between people, especially in the common areas. And so I think it's important that the association have a rule that spells out that this won't be tolerated. And it can include things like interference with vendors. We all have some owners from time to time who again feel that they own, and they do have an ownership interest, but they don't defer to the board, and they see a vendor outside and they go out and they try to tell them what to do. So that could all be wrapped up into this one type of rule, and I think it's an important rule to have. And then the other rule that I think is very important to have, and we've seen a lot of this, especially lately, is an insurance claims process. So most condominium documents establish what the requirements are for the association to have insurance and what it covers, but it doesn't really ever say much about insurance claims, how they're handled, who's responsible for the deductible. Many associations with professional management have fees from the manager when they have to administer an insurance claim. And those fees are typically passed on to the owners that are involved in the loss. So we need to have that somewhere. Now, ideally, that would be great to have amended into the documents, but often, as you know, the amendment to the documents is going to require the vote and consent of the owners. So at a minimum, I would suggest at least having the rule that would specify that. Hiring insurance adjusters. These are all things that can be part of this insurance claim process. And you kind of want to have it spelled out. So unit owners can't say, well, I didn't know that. No, we had a policy. You were given it 3 years ago and you didn't follow it. And you didn't have, we told you at that time, you can include this in the policy, that you should have your own homeowner's insurance policy. Insurance today could be an entire separate topic, but those are just some tips about having the rules for your association. So now, Lexi, do you want to go through the practical tips at the top of this slide?
Yeah, sure. So pretty much practical tips. It's just that you want to make sure that you're being consistent in these enforcement or these application of the rules. You don't want to be picking and choosing who you're enforcing them against, because that can just give rise to discrimination potentially and can just be seen as unfair. You want to make sure you're consistently enforcing the rules that you have adopted. You also want to make sure you're being reasonable. And if someone is violating a rule, well, considering what the violation is. I know an example that Janet gave recently was just like if someone's leg was broken and there was a rule where they needed to bring um, their trash out to the curb or something every Wednesday night and they didn't comply. That's kind of a reasonable reason for why they didn't do that. Should you assess them $100 fine? Probably not, because they physically were not able to do this even though they violated the rules. So that also goes with the same of exceptions. There should be exceptions for things that are reasonable reasons for why they violated the rules. You want to have an open conversation with the person who's violating the rules and try and talk to them one-on-one and see what the reason is. And if you need to go further with the legal action that you've already started, if you've used our firm or even just having your property manager send them a letter, you want to have someone talk to them and see what the reason is. So, yeah, anything you want to add to that, Janet?
I don't think so. I do think being reasonable does involve exceptions sometimes, reasonable exceptions and documented
Yes.
exceptions so that somebody can't say, well, you let that person do it, so I want to be able to do the same thing. So I think if you document your
Mhm.
exceptions, then I think that will serve you in the long run.
Yes. Um,
Okay.
okay, so I think should we go to the questions
Questions.
now?
Yes.
Oh,
I do want to go off topic though for 1 minute, because news has been breaking over the last 24 hours about CTA. And while I have a number of people on this webinar, I do want to just remind everyone that right now, CTA, which is the reporting requirements, it's still on hold, okay? You do not have an obligation at this time to file a CTA beneficial owner's interest report. So that is still on hold. There was a decision by the Supreme Court yesterday, but it has not impacted the obligation to file. It's still on hold because there's another case that's still pending that has a stay in effect. So I just want to remind everyone, if you hear otherwise, that you have to file. No, you don't. Okay. So I just wanted to clear
okay.
that up because I know that that's created some confusion. Okay, so we can go
Okay.
to questions and answers, I guess, at this point.
Yes, there are a few. So, a few different people have asked if the slides will be available. Yes, we can make them available to you guys afterwards. So, just to let you know that a few people asked that. Um, Glenn asked, how do you protect the I can't say that word, the anonymity of the complainers?
Anonymity.
Yes.
Yeah,
So,
okay.
um, I
But you
can
want
say
to answer that?
something.
You talked about it.
So when the person wants to remain anonymous, if they've submitted a complaint, you can do that. If the violator is requesting the complaint that was submitted, you can redact all identifying information and provide them that complaint. However, like I explained a little bit before, if there's only one person who has submitted this complaint, and that is what we are basing this entire violation off of, and if it goes to litigation, there will need to be someone who signs the verified complaint and who provides an affidavit and or oral testimony in the courtroom regarding the complaint. And the property manager is not always there to witness the complaint. So I wouldn't always rely on them to, sign the verified complaint or provide the oral testimony or affidavit that's needed if it goes to litigation. So it's possible to keep them anonymous for sure, because I know there's a fear of retaliation sometimes in these people who are complaining against the violator. So it's possible, but just know if it needs to have litigation, we're going to need to have the
There's,
identity of someone revealed.
there's definitely going to be a likelihood that the identity of the person complaining is going to come out. It would be something that could be discovered in litigation. Okay, all right.
Exactly.
Any others?
Yes, definitely. Sorry, just reading through. So one question is, how do we solve the problem that we cannot enforce large amounts of money in fines for major rule, bylaws, or master deed infractions? So,
Okay.
like,
I can answer that one.
okay,
Okay. First of all, as Lexi said, the purpose of the fines is to stop the bad behavior. Okay. And you can assess the fines, and they are part of the lien against the unit. If you ask me, okay, you got the bad behavior stopped, you've maybe had to fine them several $100s. Okay. You have this lien against the unit. The lien in Massachusetts, by the way, is automatic, as it is in Rhode Island. So what should you do? Should you go forward and incur legal fees to collect those fines? In my opinion, no. I don't think a court or a judge will ultimately look favorably on a case that was brought just to collect a few $100s in fines. Because remember, now we're going to incur more legal fees that you would be legally entitled to under the law, but it's not. In my opinion, it's not the best case. It's not the best case to bring. Just leave those fines and fees on the account. And when the unit is sold, refinance, or transferred, you will then be able to collect the lien because those amounts would be included on the 6D certificate.
great. Another question is, I can briefly answer this one, is what needs to be considered before towing a vehicle that is parked in violation of condo rules? So, towing on private property is actually governed by a separate regulation in Massachusetts. And in order to tow a car on private property, which would be your condo parking area, you need to either have a sign physically up on that area saying that all violators will be towed. If you don't have that kind of sign, then you need to implement some kind of notification process to the owner of the car. So some condos put a pink slip on the car that's illegally parked, and saying if you don't move your car within so many hours, you're going to be towed. Because under the statute, you have to provide one of the two forms of these notices before you tow a car. Otherwise, you are putting the condo or putting the board subject to paying for the cost of towing, which includes the cost of storage. If it's been there for months, this could add up to thousands of dollars. So it's very important that you notify the owner of the vehicle before you tow it. You cannot just tow it because they could bring a claim against you. Um, Another question is, um, how often do you suggest revising the rules? So, Jan,
I
do you want to
I
answer that?
I would say as circumstances warrant. If you I mean, if you have an issue in the common areas, people aren't handling things correctly, they're not following things correctly, then you may need to clean up the rule, add a rule. So I would say it's dependent on what your circumstances are.
Great. Okay. Sorry, one second. Um, and someone asked, can you have a rule that is not directly associated with a covenant or a bylaw?
Yes, if it's governing the common areas of the association, yes, you can create a rule, a clubhouse rules, use of the parking, anything in the common areas. The board is generally vested with the authority to establish the rule. So there doesn't have to be an underlying rule or restriction in the documents to do that.
Mhm. Someone else asked if you're putting a unit owner on, if a unit owner is given a notice of violation, can that just be emailed? How you send the notice of violation really depends on how you feel it is warranted. Some boards, if it's a very serious violation, will have us get a constable to hand deliver it to kind of bring, just to kind of make them feel the heat that this is very important. It was hand delivered to you. Usually I send it through first class certified mail, and also I will always email it to the violator. I don't think you should rely on email just because it's not a solid way to prove that they have received that notice. You want to always back it up with like certified mail because that can be tracked and proven that they received it.
I would agree with that. But I also would agree that if you are sending out your initial notice of violation, that they did something, I would say a generic type of
Yeah.
rules violation, you probably wouldn't need to spend certified mail on that. It's when it escalates and the problem's really continuing, that's when I think you need to get into certified mail.
Yeah. Someone's asked if a board appointed mediator is ever utilized to resolve difficult situations, which we didn't cover, but I do want to say that some documents actually have a specific arbitration mediator provision that unit owners can try to enforce themselves if they're in a situation where they're receiving notices and say, well, we need to go through this arbitration. Janet, do you have anything else to say about that?
No, yes, I do think mediation can help. Actually, the question's going to be who pays for that. So sometimes what we really do is we encourage board members and the manager maybe to play the role as the mediator. And the reason sometimes we obviously don't want to involve the board and the manager unless we feel it's necessary. And if it's an ongoing problem and you're getting complaints, it really it does help the association, the administration of the association, if you can eliminate this problem. So it might make sense in those situations to actually try to sit down, bring the parties together, and try to mediate it. And you can use a third party mediator. I, you could tell them you'd engage one, but I wouldn't want the association to have to pick up that expense. I would want that
Mhm.
expense shared by the parties and not the association. So I think you'd have to set that up in advance. But the board and the manager can certainly try to mediate on their own without expense.
A few people asked for us to describe, like, or to further define a nuisance or like offensive conduct. And that is a very vague term,
Yes.
but do you want, you can talk
Okay,
about that.
I'll do my best. It's hard to
Yeah,
describe, okay?
it is.
First of all, the board should remember, and so should the property manager, you can only deal with violations of your documents or the rules and regulations. You can't try to sometimes there'll be no violation. Like somebody will say that it could be a personal dispute between two people who reside at the property. I don't necessarily see that as a violation of any of your existing rules and regulations. What I would define as a nuisance, it's kind of like you know it if you see it. Someone's banging on a drum, using exercise equipment in their unit, and it's pounding on the unit below. things like that, I mean, I think that is a nuisance. And not only does the association probably, if you have the rule or the provision, have a basis to say that's a violation, but any other owner also would have a claim under common law to bring a nuisance claim against that person. So we try to also, when we can't determine who's right or wrong, or it usually does, no matter what, sometimes these do turn into the he said, she said. So in those situations, we try to encourage the owner, well, you have rights. If you feel it's a nuisance, we don't have any indication from anybody else, but feel free, take your claim and have at it.
Mhm. I saw one question about just having problems with getting a majority vote on issues, or sorry, having a board majority vote on enforcing rules against board members' friends. And how do you deal with situations like that, which I understand can be very hard. So any advice you have, Janet?
My advice would be that you as the board have to deal with violations. And while it may be uncomfortable and awkward to have to deal with a violation from a board member or a board member's family member or their friend or whoever, I think you have to have a frank discussion and say, well, this is difficult, because that is exactly the example of not applying rules and regulations consistently. If you just ignore it, then you are jeopardizing your ability to enforce that rule as to another violator. So I do not recommend that you just ignore it. I think you have to have a frank conversation and tell the person that this is a problem and you have to go through these steps. It's happening. We received a complaint. We have to get a notice. And hopefully your property manager can assist you with that to some degree.
Mhm. A few people have asked questions about renovation rules inside of like renovations inside of a unit, and can you enact rules regarding renovations inside of a unit?
It depends.
Hmm.
It depends on what the underlying documents say. Some underlying documents, many of them, give the board the right to approve structural changes. Most would do that. But general renovations, they may or may not give the board the authority to do that. If your documents have that authority, then great, you can adopt the rule to say you need to submit. I have a lot of associations that have architectural review committees that review the proposed renovations to make sure it's consistent. So yes, it really does depend. If you don't have the underlying provision in your documents, then you may or may not be able to have the rule. But certainly a rule with respect to anything that impacts the common elements, like if the renovation is going to add new plumbing lines into your common elements, that is certainly something that I would say that the board would have the authority to do. Regardless of the fact of what the documents say, because you have the authority to oversee those common areas, and anything somebody is doing in their unit that impacts the common areas gives you the right to regulate.
Great. Someone asked if an investor, owner, or a renter should be fined for a violation. So when you are fining for violations, you are fining the unit owner. The unit owner can come again, it's their responsibility to try and go against their tenant to collect on that fine, but they are the one who ultimately is responsible for paying that fine. You cannot fine a renter or a tenant, because the board is, that would be going outside of their scope of authority at that point. So you need to fine the owner,
Right.
and they will, yeah.
And that's an important point that you brought up. It's the owner that's responsible, not the tenant or the occupant. And I know sometimes we include a copy to the tenant or the occupant, and you can do that, but it's really the owner that's responsible for the unit, and that's who you should be communicating with. That's who gets fined. That's who's responsible for the actions and conduct of their tenant.
Mhm. Um, Sorry, there's a
That's
lot of
okay.
people have submitted questions, so just trying to filter through them. Um, so another question is it legal for the board to charge an owner for a copy of the rules and regulations?
I mean, first of all, everything's available electronically these days, so that's number one. I mean, if they want a full set of the condominium documents, most associations, and they want them printed and sent to them, yes. If you're sending it by email, no, I wouldn't do that. And I do think if they want another set and you have to mail it out, they should certainly be responsible for a fee associated with that. So that could be like $25, something reasonable, because you have to copy them, send them. So they're and take time away from doing something else for the association. So yeah, I think you can charge a reasonable fee, but you want them to have the underlying rules and regulations at least delivered once.
Mhm. Another question is, how would you recommend handling board members who are the ones violating the rules? So this is something that does happen. And that board member does have to recuse themselves when the board is discussing those issues involving them, because it's a conflict of interest. Obviously, they're not going to vote in favor of something that's going against them. So the board member who's violating that rule should not be involved in the discussions with the board when they're discussing the violation of a certain board member. Do you want to add anything to that, Janet?
No, I'd agree with that. I mean, I don't think they are legally obligated to recuse themselves, but I think from the
Mhm.
board's perspective, the majority should say, "This is about you. We're sorry, but we can't have you involved." And it's actually better for the association and for that person, because you don't want that. You don't want the unit owners to think, "Oh, that person got special treatment." So that's why you don't want them included, and you're doing them a favor by excluding them.
Mhm. There's been a few questions about pets, like dog bites and pound limits. So your pet rules can be specific to whatever you want. I mean, technically, but I don't know. Jan, do you want to talk about pet?
So okay, so this kind of goes back to the beginning of the discussion that we have. What do your underlying documents say with respect to restrictions in the condominium documents? Is there a pet limit? Is there a policy or some restriction in your documents? If there's nothing, okay, then I don't, in my opinion, believe that the board has the authority, and in this case law on this, it's fairly clear that you don't have the authority to establish a limit for the pets in the unit. And in fact, this does bring up one case that Lexi and I discuss from time to time, which is it was a case that was in Massachusetts many years ago. And basically, the association wanted to limit the size of dogs in the unit. So what they did is they created a rule that basically said you can't have pets in the common areas. You have to carry them in the common areas. So someone got a large dog, 90-pound dog, Michelangelo, and they had to walk it because they couldn't carry it. And ultimately, the association filed a legal action against that owner, went to court to say this person can't walk the dog in the common areas. And the court struck down the rule and said it was not a valid rule, because effectively what they were doing was really impacting the use of the unit. You were trying to regulate the use of the unit through a rule. So if you all that you have is just rules and regulations about pets being in units, you that is not going to be found to be enforceable. There are several cases on point about that discussion.
Mhm. A few people have asked questions about installing cameras in the common areas and if you can install a camera to, catch the violators in the act. And also in situations, someone was asking about, not being able to determine who exactly is committing the violation. Do you want to
Okay.
discuss?
Can't okay. Cameras in the common areas. I would say that most associations, if not all, have the authority, because it's the common areas, to install cameras. And we do actually encourage it many times. I don't want to say serve a security purpose, but they do make people feel better. They're certainly not security, because no one is manning those cameras, but it's not a bad idea sometimes to have cameras in the common areas. What gets tricky about having cameras in the common areas is then unit. Oh, great. I want to look at that because I need to see who went near my vehicle or did something. Okay. The cameras in the common areas are not for unit owners to really review. It's a board tool, okay, manager tool. And you would maybe, if they request it and they have a valid reason, you would go back and look at the footage. But it's not something that you would just give out. You would give it out to the police if they asked you for it. If there was a subpoena for it, you would give it out. But you, other than that, this is not, oh, they want to see who came in with somebody else in the common areas. So I don't recommend that the footage be available for unit owners to view. Also, and not a bad idea, is if you do have cameras in the common areas, you can actually have the rule that says this is our policy. It's not going to be available for any unit owners to observe. It's only going to be used if there is some need by the association.
Mhm. Another person asked, how do you deal with owners who have too many tenants, like over Fannie Mae limits? So when it comes to occupancy limits, that can be a tricky subject just because if someone is having a bunch of people living in their unit that you know is like beyond any kind of um, state regulation because there's sanitary code regulations regarding the number of people who can live safely inside one unit. And your condo docs may also establish, like, no more than two people per bedroom. In those situations, you have to be very careful because it can, depending on the group of individuals, it can easily lead to a claim of discrimination, like either for, based on familial status and all the other kinds of discrimination. So you have to be very careful if there are, and you also need to have solid evidence that this is way above what is, allowed and it's causing a problem. So in cases like that, you just have to have a lot of proof that this is not allowed. And, do you want to say
Yeah,
anything else about that? Mhm.
I would agree. The state sanitary code, believe it or not, has very you would be surprised at the square footage that multiple people can live in. It's
Mhm.
not likely that that would be violated. So I would be careful about that, and you do want to avoid any discrimination claims.
Mhm. Um,
We
another
keep going for a few minutes. I know we're past
Yeah,
our hour,
there's
but
lots of we can go for a few more minutes.
we
There are a lot of
seems like there's quite
questions.
a few questions, but we don't mind taking a few
A
more. So
lot.
maybe we could look at them.
So another question. Sorry. Just trying to filter through some of these. Um, So someone asked about enacting specific rules regarding electric vehicle chargers, which is actually something that we deal with a lot here at MEEB, because a lot of people are buying electric vehicles now. It actually an update to the Massachusetts condo statute was adopted recently that essentially requires boards to allow a unit owner to install an electric vehicle charger in a common area if they request it, and the board can allow or require some type of application process, but they cannot like unduly delay someone's ability to install such a charger if they do request it. Usually we have them sign a revocable license agreement with the owner if they are doing that, so you can restore the area back to its original condition if they sell it, or else it transfers with the unit. So yeah, did you want to say anything else about that, Janet?
No, I mean, obviously, I think we have to respect the fact that we are heading in the direction of electric vehicles, and we need to kind of figure out how we deal with that as an association. Hopefully, you have the ability to have some in your common areas. They can also be like a central bank if you have spaces available in the garage or outside where you can install a common system, and that would then eliminate the need for individual systems. So that's something to look into.
And another person asked, is it common practice to have rules that require at least two unit owners must make a complaint in order for it to be addressed to the unit owner? And again, no, that's not a common practice I've seen. However, like I discussed briefly, like if it's only one person complaining, you want to make sure that it's detailed complaints, it's consistent. It's not just maybe, sometimes it can be seen as targeting a certain person if they're constantly complaining about someone and it maybe is like a minor violation. You need to be hesitant if it's situations like that. Just use your common sense, I'd say.
Yeah.
And if you think it needs, like I said, to have a third party corroborate that information, it may be necessary. Otherwise, it's just a he said, she said situation, which is hard to defend in court occasionally if you need to go to court. Um, so there are a lot of questions. I think we covered a lot of them. Um,
All right.
I'm trying to see if there's any other ones just briefly. I'm sorry if we couldn't get to all of your questions. I
Well,
am you so
all right. Maybe one
I think
last one.
we
How's that?
yeah, well yeah, one last one. So
Okay.
one second.
That a good one.
I
Hmm.
know. I'm sorry for the
That's all
brief
right.
pause. A lot of people have just been asking questions about fining and legal fees and how to how to start doing that and how to assess them to the unit account. Kind of just that's just broadly what I've seen. Just I've seen a lot of questions about fining and legal fees. So Janet, do you maybe just want to go over
Okay.
it's just
So
important. Yeah.
okay, when you levy a fine, when you send out the notice, I again would recommend that you send out a notice. Then you would also have posted to the account for those associations with property managers. You would have the property manager post the fine to the account. Okay. And probably the property manager would also send out the notice. I like to recommend that you send out when you levy a fine, there should be a letter that goes out to the owner. Doesn't have to go by certified mail, but just something in writing. It can be by email. Just putting the unit owner on notice that there was another violation and they're being fined. Those charges get posted to the account. Now, if that violation continues and you engage counsel, typically when counsel deals with it, there will be a submatter for the billing on that particular unit. And those charges would then, when you get the bill, property managers do this routinely, they would take those charges and post them to the account for the unit. So they do actually get on the account, okay? And they are a lien in Massachusetts and Rhode Island until those charges are paid.
Mhm.
Okay. All right.
This just one last question because I
One
saw this
last one. Okay.
person. Yeah. So how do you handle a situation when a board member is trying to change rules explicitly to benefit themselves, which I thought was an interesting question. We may have
Okay,
kind of
that
already
is.
gone over it, but it is a complex situation that you kind of have to handle. And you have to remember when you're adopting new rules, you have to follow what is required in your documents, and that requires a majority vote. So if it's only one person trying to adopt new rules, you have to explain to them that this isn't the process, this isn't a legitimate rule unless we all have voted in the majority in favor of it. Now, there may also be, I've seen occasionally, ways that people can contest adopted rules under their documents, like it would require like I've seen randomly a certain amount of unit owners have to call a meeting and then they have to have that meeting specifically to discuss why the rule should be removed. But that's just a very broad answer. I understand how complex it can be when there's just battling personalities on a board.
Right. Definitely, it has to be a majority vote at a minimum to adopt the rules.
Mhm.
And board members should remember and understand that you're supposed to be making decisions that you believe to be in the best interest of the association. Not any one particular unit owner or board member, but the best interest of the association. And you don't want to have a rule that really only benefits one person because then that leads to unnecessary rules and all the things that we discussed at the beginning of this.
And then one other question I keep seeing is just about rules in New Hampshire. And I do want to say that for legal fees, when legal fees are incurred on a violation matter in New Hampshire, they are not automatically accessible to the unit. That is something that's specific to New Hampshire. You have to find if there is any in your governing documents for New Hampshire that says are able to assess the legal fees associated to that matter to the unit owner, which some documents in New Hampshire do have, but is not written in the statute. But if it's in your condo docs, then it's completely enforceable. So I
Right.
did just want to
And
mention that.
remember in New Hampshire, for those people who are here from New Hampshire, it's not an automatic lien either. You have to file a memorandum of a lien to actually have a lien against the unit. So keep that in mind. Okay, all
All
right.
right.
Well,
Yes.
thank you, everyone. We hope you
Thank
enjoyed this, and
you.
we hope that you have a better understanding of rules and regulations and the enforcement process. If you don't, you're certainly welcome to call us, and
Hmm.
hopefully we can help you through. So thank you for
Yeah.
joining us.
Yes. Thank
Bye,
you.
everyone.
Bye.